Hello and welcome to another update video from Portway Solicitors. I am here today to provide some insight into ACAS, the Advisory, Conciliation and Arbitration Service, which has been an integral part of employee disciplinary and grievances claims for nearly 50 years. ACAS is an independent public body whose main aim is to improve workplace practices and relationships. Through early conciliation, it provides a platform for disputes to be resolved between employees and their employers before a claim is started in the employment tribunal. Some types of claims do not have to go through early conciliation and can be started directly with the employment tribunal, but it is important to seek legal advice in order to know whether your claim is exempt or not. ACAS also provides a number of services such as guidelines on employment rights, best practices and policies, along with resolving workplace conflicts. ACAS also facilitates the resolution of disputes through services such as arbitration and mediation. It is important for an employer to note that failure to adhere to the ACAS Codes of Practice are not illegal, but can result in an additional compensation of up to 25% to an employee if a claim is won. I will go through some key elements of the ACAS Codes of Practice. The disciplinary and grievance procedures. This code covers disciplinary situations such as misconduct, performance raised by employers, and grievances which are complaints raised by employees. Any complaint of a misconduct or a grievance must be in writing. This process for reaching any decision should be fair, transparent, and should be dealt with promptly within a reasonable time period. Employers are recommended to hold an investigation and a hearing in cases of disciplinary action with a different person handling each stage of the investigation to avoid biasness. An employee should always be informed of the facts, the procedures, all the evidence being relied on, as well as the potential outcomes of any investigation or disciplinary hearing being conducted. Any action taken by the employer is to be proportional in nature, and dismissal should only be considered if the misconduct is serious. Appeals against any decisions are to be dealt with fairly and reasonably. Next is early conciliation. Prior to making a claim with the employment tribunal, it is mandatory to inform ACAS of the intention to file a claim. ACAS will ask an employee or employer if they wish to engage in early conciliation. If you opt for early conciliation, ACAS will request additional information on the dispute. Thereafter, a conciliation officer will be assigned who will liaise with both parties to understand the dispute and the outcomes hoped to be achieved. Some employees choose to instruct legal representatives to also handle this process on their behalf. If an agreement is reached, a COT 3 agreement is issued for parties to sign, which will be legally binding once completed. If either party refuses to come to an agreement or engage in the process, then ACAS will issue a certificate within 1 month of being notified. You then have a minimum of 1 month to make the claim with the employment tribunal. However, there are different limitation periods for different types of claims. Again, it is important to seek legal advice in order to know. Finally, we have the requests for flexible working. Employees now have the right to request for flexible working arrangements from day one of their employment, which employers are required to consider on a reasonable basis. A revised code was published on the 6th of April 2024 to that effect. Please note that ACAS is an impartial organization which facilitates resolution of disputes and are not legal advisors. Here at Portway Solicitors, we can help you with any employment-related matters and give you advice tailored to your needs. Please contact us for a free consultation at your convenience. Until then, take care and thank you for listening.